But Migle, if you just want to introduce yourself, just tell us a little bit about yourself, and then you want to jump into your presentation.
I think that's a good idea. So can do that. So hello, everybody. This side of the screen and another side of the screen. My name is Migle ukauskaite Tatore, and I'm calling in from Lithuania. And obviously, I'll be talking partially about, in part, about culture and traditions in Lithuania, but also a bit wider perspective in Europe. So I guess whenever we talk about culture and traditions, it's always important to understand where the person talking about those traditions is coming from, what's the background, and why he or she formed a view that they did. So just a couple of words about myself before we begin, and kind of for you to understand where my perceptions are coming from. So I'm a lawyer, a mediator, and a mediation trainer. But my biggest part of getting to know mediation was actually through research, because this was my way of choosing, of kind of getting to know it and diving into the subject. So as I was doing my Ph.D. on it, and I was researching on mandatory mediation models in Europe and Lithuania, and trying to understand if they're effective or if they're not. And I've also worked as a scientific expert for the working group on mediation with the Council of Europe, CEPEJ. And there I got to read, I think, at least 17 different legal acts on mediation from 17 different countries. So it kind of made me aware of the legislation on mediation and how it is being taken in Europe. I'm also, as a mediator, I'm usually mediating family disputes. So this is kind of my main area in mediation. And I've been also teaching in university for several years now, different subjects, mainly in civil law. So this is where I'm coming from. And even though I do mediations and practice them, but again, I usually see mediation through the lens of research, of trying to understand how it works, and again, if it's effective or not, if the models that implemented are effective or not. That's, can't say briefly, but about me. Trying to run away. When we're talking about culture and mediation, I think for me, the first kind of stop is to start where it is coming from. And we can talk about history. I remember when I was doing my PhD research, I was trying to understand where it is coming from, where mediation is coming from. As Vikram rightly said, no, it's not that it just happened. We had similar traditions in early ages. But then trying to look through the research of it, I wasn't able to find a lot of sources that would state that. The only thing that I could definitely grasp was about similar practices in China before BC. It's a couple of hundred years BC. And this was kind of the scientific source that I found. But I also came across kind of different examples of mediation, or at least something similar to mediation. We cannot know for sure what was happening there, but similar questions, similar processes happening in ancient Greece, ancient Rome. Phoenicians, at least it is said, had similar practices. The African La Palabra tradition. And this is kind of all the history that we are building it on, at least in kind of the world scale. But I guess together with the history, we also kind of start building associations. And if we come to these days, we see that some associations are happening, at least for me. Let's say if I'm thinking about mediation in the US, I'm usually thinking of that more elaborate evaluative model and kind of retired judges. And I'm sure it's no longer true. Not only retired judges are mediating, there are a lot of different people and a lot of different styles of mediation, but that's the association that first comes into my head. And if I think about Italy, the first thing that comes to my head is the mandatory mediation. So that's kind of the associations that we start to build when we know some we know something about what's happening there. And they're not necessarily true, but this is how we see it. And I think another very important thing about building the culture of mediation, because again, I think that the culture of it now, it's what we create, how we form what mediation is in our countries, in the kind of social circles where we are, how we are working. And I think that the context, at least in, let's say in Europe, it was the fact that the supply actually still outgrows the demand for mediation, at least from what we see it. And, been talking about the European mediation paradox for what, 10 years now already, a bit less maybe, but still it's the context that we are living in. And especially working with those different countries, reading the laws on mediation, you understand that through the legislation, we are kind of trying to bridge that gap, to make mediation available to the public, to remove that mediation paradox and kind of make even the supply and demand curves. And this is the context that we are living in, at least in Europe. And the mediators that I've been talking to, it's kind of one of the main questions is how to make mediation popular. We all know that it's a great tool. There are a lot of well-prepared, well-qualified mediators who haven't actually conducted a real-life mediation. So I think this is very important thing to understand when we start talking about how we build the mediation culture in a specific country. And I think this is where legislation come into place. And again, at least through my research, my main conclusion, at least this not the scientific one, but something that I came across myself, was that we think about mediation as a social phenomena. And when we're talking about culture, we're talking more about, that neutral third party that helps one and then helps another and kind of facilitates the conversation. But at the same time, we have to admit that legislation changes a lot of that. In a sense that if we implement a mandatory mediation model, the concept of mediation will kind of change how we understand, because this is how we are told to understand it according to the legal acts that were implemented. And especially when you read several different legal acts in several different countries, you see that mediation, even though still the same process, it's taking a slightly different curve into another direction. And I think, again, legislation also forms the culture of mediation. This is where we are going. And I think this is, again, what happened in Lithuania. And I think that in Lithuania, we went through those things, through all these stages. And I will talk about it a bit more, or actually a lot of more, because I think that is important to understand of how certain processes work in mediation in Lithuania, what's the history behind it, and where it took us after a while. So I think that it all started similarly as in Europe. It was kind of acknowledged that there is such process, but I was trying to go to the kind of legal acts from earlier days. And in Lithuania, the earlier days is kind of when we started out building our own legal system after the independence, 1990s. So 1996 is still pretty early on kind of that, let's say, modernish legal basis. So the first one that I found was the law on arbitration. And arbitration was kind of understood and well known, and there was a law as early as 1996. And then it kind of referred to some kind of pre-arbitration conciliation. It wasn't called mediation. It didn't actually provide any substantial information of what it is. They were actually referring to mediation and referring to UNCITRAL rules on how to conduct it. This was kind of the first mention, and for a long time afterwards, there was nothing on it, except for enthusiasts who found out about the process and wanted to take it further. But there is not much information on that. And then with the introduction of our new Code of Civil Procedure, there was also kind of a mention about possibility for the judicial conciliation. Again, that was not a mediation. That was a completely different thing. You can't say completely different thing, but basically judicial conciliation in that sense, where it started, was understanding that the judge has the right to and an obligation to at least try and offer the parties to reach a peaceful settlement. But I don't think they had the skills that mediators have, and the process and the safeguards that were there, they were completely different of how we understand mediation. It was not confidential. The same judge would then continue with the legal proceedings afterwards. It was transcribed, the whole process. So it was not the same as mediation. However, when people were very eager to push mediation forward and there was no kind of legal background, legal basis for that, they used this article of that the judge can kind of conciliate the parties. So we can kind of slip that in. Of course, afterwards there was a new article which encompassed the judicial mediation and kind of in all its glory, but this is where it started. You kind of had to look for those small places where you can kind of jump in and build mediation practices. So, as I said, those enthusiasts who really love mediation, who heard about it and participated in different working groups, they decided to start with a pilot project in courts and kind of to make mediation popular in that way. It all started in 2005. It started with one court, but there's a reason why I'm talking about that and why I think it is important. Because these pilot projects, the fact that it started in courts, the fact that it started with judges and assistant to judges as mediators, it had a huge effect throughout these, almost 20 years now. And I will talk about it more a bit later, but now kind of mediation is still more related to the judges to a certain extent because of these pilot projects, because this is how it started. So these pilot projects, there was a kind of working group established to start the processes. The judges were trained to conduct mediation, and the assistant to judges were trained to assist mediation, to conduct mediations. But then the general public, at least at that first in those first steps, were not allowed to mediate. It was only judges and assistant to judges. But they also kind of foreseen some funds to disseminate the information about the project, to make it more popular. And as I said, they used that article in the Code of Civil Procedure, saying that still think that the judge can conciliate the parties, so we can put the mediation in there. And then the Council for Judges, the Judicial Council as it's called now, they adopted the first rules on mediation. Again, they're kind of regulating the provisions of that's supposed to be regulated in the Code of Civil Procedure. So they didn't really have the power then, I would say, but it worked in the day. And then, of course, kind of the initiatives were first, and then the legislation followed to kind of allow these practices afterwards. But this was kind of the first comprehensive, at least kind of more comprehensive rules on mediation that we had in general. And afterwards, that pilot project, and again, remember, we had no legal acts on mediation at that point. So there was only that law on arbitration that was kind of referring to pre-arbitration conciliation, and only that Code of Civil Procedure. We did not, it didn't feel that was necessary to regulate this thing. So in 2007, the pilot project got extended both in scope and in time. And we could see more courts joining. I think in total, they ended up having, 14 courts that joined the project. It was also open to the general public, as in people who are not working in the court could be mediators as well. However, that kind of the first I think, the first step towards kind of giving mediation to the judges, it stayed, and not a lot of people wanted to be mediated by kind of lay parties, the non-judges. And I think, again, it kind of set the scene for what happened afterwards. It was decided that mediation can take place for up to 4 hours, and if needed, this can be extended. But still, those 4 hours were kind of brought further into other legal acts and into other redactions as the versions of the law on mediation that will be passed later. However, what we've seen is that still in let's say 2015, quite a few years after it was implemented and it was already live in all the courts, there were only 123 mediations per year. In 2016, more, 313, and Lithuania at that time, there was around 3 million people. Still, these were not huge numbers. And then the understanding came that we need a law on mediation, because, and this is, I think, that the common sense that's going, shared understanding that's going on in Europe, is that if we want to make mediation popular, we have to start with the regulation. And I think a lot of countries are hiring experts to help them implement laws on mediation, to help them prepare laws on mediation, to look into the best practices of other countries. And I think even through that, the culture of mediation is spreading. Again, the Italian model on mandatory mediation spread to Greece, spread to Turkey, to Azerbaijan. They are still a bit different. They are still applied to that legal system, but through laws, through like regulations, we're spreading it around other countries around Europe, and kind of showing our model, and it stays. So, so after that, after the decision was made to implement the law on mediation, and I have to again come back to another thing which happened in almost the whole Europe. Around that time, the mediation directive was adopted, the European EU directive on mediation, which was kind of the catalyzer, the start, the trigger for a lot of EU countries to come up to implement laws on mediation, because it was not regulated, and the mediation directive, as it was a directive, so it had to be implemented in the national legal system, even though it was only for the cross-border disputes. But there were a lot of countries that implemented that law around 2011, 2012, and because this was the deadline when the directive must have been implemented. In Lithuania, we kind of started a bit earlier during the discussions of the working group and all the travaux préparatoires. The provisions of the future directive of mediation were taken into account, and it's a very similar legal act to what directive actually entails. It's talking about confidentiality. It's talking about prescription limitation periods, some definitions, nothing substantial. It's just more of kind of showing that the state recognizes this as a process. It recognizes it as a dispute resolution procedure. Even starting with the pilot projects, there was also already an option to homologate the settlement agreement. So whenever there was a settlement agreement, parties up until now, they can, if they both agree, they can go to the court, and it will be passed into a decision, and it will be an enforceable title. So all these aspects that were there, they were regulated, but again, it did not generate a lot of traction. And when 2011 came, when the deadline to implement the EU directive came, we've seen kind of a bit of several changes to that first version of the law on mediation. And it was talking more about the cross-border aspects to it, kind of broadening the scope, the powers of the of certain authorities. So let's say the same Judicial Council, what they can do with mediation, what type of legal acts they can issue. It also became a part of legal aid scheme. So kind of it went through, it was pushing forward, but it was still a very generic legal act. And again, as the numbers that I told you about, the statistical numbers, there were only a few actual mediations happening, or at least if they were hiding somewhere very deep. So we did not know about it. But then seeing that there is no traction, there were a lot of talks of what to do and how to make mediation popular. And still the most effective way, it has its own risks. It has its own kind of downsides. But from everything we've seen, the mandatory mediation models are still the most effective in making mediation popular. So in 2019, that huge change came in with the legal act, with the law on mediation. And there were several kind of, it became the most comprehensive, I guess, as could be, because usually when we talk about legislation, I think that Nadia Alexandru started kind of this grouping of laws on mediation, and we can, of the functions that they may have. So this law, it had all the functions, starting with the triggering ones. So it started like it was implemented in 2020, the mediation in family disputes, mandatory mediation as a precondition filing a claim in court. It also came with a change of allowing the judges to order the parties to use mediation in any dispute that they see fit for that, and where is the high likelihood of peaceful settlement. It also regulated all the procedural aspects, because when you introduce a mandatory mediation model, you cannot just let it flow, because in that stage, the state becomes at least partially responsible of the quality of mediation, because it becomes a part of the legal system. So it's not just what private mediators do and what parties agree to, but if we are, in a sense, forcing parties to go to mediation, we have to ensure that the quality will be high and that the process will be regulated. So it still stayed in that model. When I'm talking about process, so it's when mediation starts, how you appoint a mediator, when it finishes. So all of these aspects, they are regulated, but thankfully they are all regulated with an if parties do not agree otherwise. So it kind of still allows to maintain the flexibility of mediation. However, if parties do not understand the process, or they don't want to change anything, so there's kind of a model that could be used. It also introduced the provisions of kind of securing the integrity of the process, so the confidentiality, prescription, limitation periods, and so on. And it also, I think, the most important part of it, and this is why I like mandatory mediation models being introduced in different countries, because usually it comes with quality assurance. And when I'm talking about quality assurance, is the fact that we now have a list of mediators who, in order to get on the list, you have to go through a training, you have to pass a exam for mediators, you have to continue your professional development in order to stay on the list. And there is you can be liable for not following your duties correctly, in a sense of you can be suspended on the list, or can be removed from the list. So these are kind of aspects that actually ensure the quality. Of course, we did not go as far as Giovanni might correct me, but we did not go as far as let's say Italy, having the lists for trainers, for mediation trainers, for mediation services providers, and mediators. So for us, it's only mediators, and still kind of anybody who wants can train mediators. And I think that's kind of another step that could be taken. But this second version of the law on mediation in 2000, which came into force in 2019, it actually encompassed it all. And I think that was a huge change. But I think with the introduction of mandatory mediation, it also changed the perception of mediation, at least in the eyes of the parties. But I think it will affect the mediators as well. So I will talk about mandatory mediation a bit more, so I will not start about to touch upon it now. But kind of, I guess the last change that we had is in 2021, there were like even a third version of the law on mediation, not that it changed a lot, but that we encompassed disputes and administrative jurisdiction into that law as well, kind of give the ground for it to take place. Of course, only in those disputes where a peaceful settlement is actually allowed. So that's kind of the historical background of what Lithuania went through all this time. And this is what we have now in terms of different mediation types. So starting with a pilot project, we have judicial mediation, and we still have the active judges, which I think, at least from what I've read, and what I've read in other countries, it's very rare to have active judges acting as mediators in judicial mediation cases. Of course, they are not allowed to decide on the merit in that case afterwards, but it's still kind of an interesting, I think that's the interesting relic of those pilot projects. And we've been talking with chairmen of different courts, and for them sometimes it's even a problem because they cannot assign cases in second or third instance courts because that judge has already mediated a case in first instance. So it kind of comes with different kind of results of how we choose to implement that model. And we also, of course, have the out-of-court mediation, and at least the part of mandatory pre-trial mediation as a precondition of filing a claim in court. It's considered the out-of-court mediation. We can also talk about mandatory and voluntary mediation. And again, in order to kind of understanding the benefits of it, mediation became a part of legal system. So for parties who cannot afford legal aid, mediation would be provided free of charge. At the same time, in different districts, families can get mediation as well free of charge as a services that are provided to the families. And we also have mediation in kind of all three types of disputes. We have mediation in civil disputes, and this is where it all started. And I think in a lot of countries it started with civil disputes. But we also have mediation in probation services and have mediation in administrative disputes. Again, judicial and out-of-court mediation. So I would also want to talk, and we don't have to go into the details of how mandatory mediation works in Lithuania, but I thought that it is important. And I think it is important because the most people who are exposed to mediation these days, they are exposed through mandatory mediation. So they only kind of see the model of mandatory mediation. And I think that at that point, they think that this is how it always works. So in Lithuania, if you want to mediate, which is obligatory in family disputes, for now it's only family, and we had recent changes to the law on mediation, which introduced an exception for domestic violence cases. So in these cases, people are not required to mediate, but in other instances, when there is a divorce and they cannot agree peacefully without mediation, if you want to decide on children alimony, on the way that the relationship with the child will continue between the parents. So all these cases, they go and they have to go to mediation. And of course, there is a possibility, as I said, unless you agree otherwise. So there is a possibility to just find your own mediator and go to that mediator, but then you have to pay for yourself and for the mediation services. But you can also just submit a request to a state guaranteed legal aid services, which is kind of the institution that oversees the mediation. I think, again, the reason why it was chosen for that, and we did not come up with a new institution of some kind of mediation council or something like that, mostly because it has already conducted mediations and provided mediations in the scope of legal aid services. So it was something that was already closest to that. So they were assigned to kind of oversee these matters of mandatory mediation and assign mediators to the cases of mandatory mediation. So in general, the process works. It's either both parties agree that they go to mediation and they know they want to get divorced, let's say, they submit a common request for mediation and then just a mediator gets assigned. I would say, can't say randomly, but kind of trying to distribute the workload between all the mediators who entered into a contract to provide those mediation services in mandatory mediation schemes. But it can also happen that, and in most cases it happens that only one side, the claimant, the future claimant, files a request. And then if the other party doesn't reply in 15 days or replies with a negative, that's all. That mandatory mediation is done and both parties can go to court and settle that dispute there. So in essence, this mandatory mediation is only mandatory for the potential claimants, not for the defendants. But then if both of them agree, so again, a mediator is assigned from the list. Of course, he has a choice, or she has a choice to agree or not to agree. But then it kind of, I think this is where the interesting part starts. So it's okay if that's a mediator chosen by parties' choice. They agree on a fee, they sign a agreement to mediate, and they kind of decide on everything, how the process will take place. But if the mediator is assigned by the legal aid services, so then we start forming certain expectations how the mediation will look like. So first of all, it is free of charge for the parties for the first 4 hours. Additional fees paid for the mediator for the first hour to prepare for the mediation, and one more to kind of conclude the mediation. So mostly it is talking about preparing a settlement agreement. And in this kind of the way the fee structure works, there are a couple of things hidden. And I think, first of all, parties are starting to understand mediation as something that has to happen very quickly. And a lot of people agree that 4 hours is not enough to conduct a proper mediation. And usually there is not enough time. And of course, not everything can be covered from the state budget. And parties have the possibility to, if they like the mediator, they can agree with the mediator that they want to continue the process, and they do, they can simply go over those 4 hours, but then they are paying mediator themselves. And usually parties are, of course, sometimes they're willing to do that. In most cases, they just see it as something given. But then there is another thing, is the fact that mediators are being paid for kind of conclusion of the mediation, and they're giving that hour. And there's kind of, again, an expectation that mediator will be the one who will prepare a settlement agreement. And that is not an obligation. However, given it is introduced, like there is that part of the fee that is provided for this. In certain cases, it feels like, and parties are dissatisfied with if the mediator doesn't want to prepare a settlement agreement. And the most interesting part of that, I guess, is not all mediators are lawyers, and they are not required to be. In order to enter a list of mediators, you have to have a higher education degree. It doesn't necessarily have to be law. So not all of them are lawyers, and of course there are certain drafts, and given that's kind of just family disputes, so most of the situations are very similar. So you kind of go right on that. But again, I think it kind of sets the expectation of how it should look like. And then kind of with the finalization of it, it's a similar process as everywhere, I guess. It's either not reached and the parties can go to court and have their proceedings as they would have expected, or the settlement is reached and the agreement, that settlement agreement is signed, and if they want to kind of homologate it in court, they can go there, and if not, they don't. And it doesn't need to be mandatory mediation. As I said, it can be in every type of mediation. The settlement agreement can be homologated in court. But I think all this history of how Lithuania went through mediation and how it was implemented and kind of how it started, it formed our culture. It formed the understanding of mediation in Lithuania, because we did not have many practices before that. We kind of grew with the legislation coming in, or maybe we grew first and then the legislation came in. But I think then there are kind of those three essential, in a sense, takeaways, is that starting with those pilot projects, maybe that's not the only reason. I'm sure there may be a lot of other reasons, but judges are still kind of the most desired mediators. Even though they are only allowed to mediate judicial cases, they cannot mediate outside the judicial mediation scope. But even when people come to mediation, they are still looking for that authoritative figure. Not always that they understand that you are not a judge, and it sometimes takes a rather long while to explain your role. What are you doing here? Because for them, they were looking forward to a court, and then there was that additional step. So what are you going to do here? And in a lot of cases, they are waiting for that decision of you telling them what to do. And then it takes a while to kind of give the responsibility back to them and saying that in this stage, you will not be making a decision, they will be making a decision. And it feels that for them, at least at this point, it's very hard to understand. It's a very, very interesting, very different process from what they were expecting that's going to happen. And I think the same thing goes to the mandatory mediation, is that, as I said, since people were exposed to mediation mostly through the mandatory mediation model, they kind of looking to, we formed that association again, saying, it's like and with my students, when I mention mediation, and I ask them, okay, so what do you know about it? Have you heard about it? So for them, the first associations of family disputes, because they've heard something about the family disputes. And again, it takes then a while to come back that, yes, in Lithuania, it is most popular in family disputes, but it's not the only place where we can use it. And I think, again, and remember in the beginning, I said that we kind of built, the things that we create, the things that we implement in the future, they are kind of seamlessly carried towards in other years and other legal acts. So let's say the same thing with those 4 hours, with those 4 free of charge hours for the parties that they can mediate for free in the mandatory mediation or judicial mediation as well. It actually started with a pilot project as well, with those first rules on judicial mediation, because there we come with a number, okay, like mediation should last for 4 hours. And then we can decide to prolong it or not. And then that 4 was carried towards and towards and towards, because it's just a familiar thing. And it's easy now to build on that, the same number. So this is the main thing, is that we carry those early decisions to later years, and it's then very hard to kind of switch the perspective. And I think again that especially with regard to mandatory mediation, we can see that that perception of a mediator as a mediation as a profession is actually slightly changing as well, because it's still kind of in between a lawyer and a mediator, a judge and a mediator, and it stays in the party's head. That's, of course, it depends on the mediator that they see and they come across, but this kind of stays in their head, that, oh, maybe that's kind of the authoritative figure, not necessarily the one who's building rapport and getting into the relationship with the parties, into that kind of trust, building the trust, but it's more of kind of understanding that, oh, that's the mediator, should be something similar to a judge, and therefore we have to listen. So I think these findings come with the legal acts that we are implementing. But I guess all in all, for me, the culture on mediation, it's something that we create. This is something that we decide to create. That's the decisions that we make when, again, implementing the legal acts, when choosing the way how the mediation will take place, and what we carry forward, which I think is a good and a bad thing. On a huge scale, it depends on us. We can turn it into a strange corner, but at the same time, we can also put efforts into creating the culture of mediation and taking where we want to take it.
That's it, Migle?
Yes, that's it.
But tell me, Migle, is the Lithuanian, the society very litigative?
Based on statistical data, I would say no. And actually, okay, I will divide this question. Based on the research that I've read, I've heard a lot of people saying that that's a litigated society. But based on the statistical data I've seen, I wouldn't say so. And in the past few years, the incoming cases in courts, they're decreasing. They're not going up. They are decreasing. We have one of the fastest processes, at least in civil courts, and kind of fastest judicial proceedings in the country. So, at least on the European level, one of the fastest. So, I don't think that that's the very litigious community.
Well, I don't know, Migle, when I see the statistics, it shows me 3 million people and 225,000 cases filed in court. Can you imagine if that happened in India? If that percentage happened here, you can imagine we already talk about a large number of cases going to court. That's nothing then. So I think that way, if you look at that in terms of percentages, it's quite high.
In a sense, yes, but like, again, if the court process is relatively quick, so then the machine works very quickly. So maybe we don't feel it that much.
But I'm just thinking.
But there's not, it's that phrase that, oh, I'll see you in court. It's not that common. I think that I hope that people still try to, find ways to resolve issues.
10% of, in terms of the population, 10% of that population goes to court, or even, that's a very huge number.
I think Where are you getting your data? I need to open that.
I'll open that. I'll make it easier for
Last
you.
time I checked, it was 150.
No, that was civil cases. That was the number of civil cases.
Yeah.
But I think no, but the important thing is that means there is a huge potential for mediation, because I see the number of cases in courts, only about 330 cases finally went for mediation. So I mean, I just feel that there is so much to happen. This is what happened in terms of cases in Lithuanian courts. So 150 civil
Oh, I think I
cases.
haven't stopped sharing my screen.
Yeah. So that's my screen.
Oh,
That's my
bye-bye.
screen. Yeah. So I'm saying that in terms of numbers, but when I see the statistics in terms of the mediation, I mean, I find it only 330 cases. That means a lot of potential. Let's just look at it as a lot of potential here.
I think
This is what it is.
with regard to mandatory mediation, with regard to mandatory mediation, you're looking at judicial mediation. So at least with regard to mandatory mediation, there were like
I didn't find anything on that.
Yeah, no, it's not here. But there were, I think, a couple of thousands requests filed more in a year. And, we have to remember that mandatory mediation only started in 2020. And I think the first half was very promising in a sense that the success rate was around 50%. Till the end of the year, it kind of went down a little bit to 30 something, but still, I think at least kind of the most excitement for me is where you come across parties who haven't heard about mediation at all, never. They don't know what it is. And then you start talking to them in that mandatory mediation model scheme. And, they start with, oh, you don't know him or you don't know her. That's going to be impossible. Like, we've tried this so many times and nothing happened. And after those 4 hours, get out of there with an agreement. And they're, it's like kind of seeing, for them, it's kind of seeing somebody to perform magic. Because like for them, it was so unexpected that this can actually happen. And I think that's kind of the best part of it, is people who really did not think that that may work in any way. Somehow they see that, whoa.
And the best part, Migle, is, it's not just family matter, because I do high value commercial. The same thing happens there. People think it's not going to happen, it's not going to work, and when it does, they're also amazed. So I think that way they have to taste it. They have to taste it, and that's where I think they have to reach out. But what about? But in terms of private mediation outside the court system, what is happening there?
Yes, there is. There is private mediation. The same way as everywhere, just enter into mediation settlement agreement to mediate. But the problem with it is that we don't have that much statistical data on it. And, in every possible working group who I've been on, trying to push for countries to collect the statistical data so we could understand what's happening on a better terms. So now we are lucky because we have that mandatory mediation. We can see, and then that legal aid service is obliged to collect statistical data on that regard. But again, they only see the cases that went through mandatory mediation system. And judicial mediation, we can see the numbers because the court administration is collecting those numbers. But with regard to the private one, we don't hear about that. But I know for a fact that this is happening, but I just don't know what are the levels. And I think kind of the most potential it has again is with cross-border cases, especially in family disputes, because there are just a lot of mess with different courts and which one to apply and where it should take place. So for people, in most cases, it's just easier to mediate, to avoid all those questions, and if they are successful. So again, we come back to the mediation directive, and they can simply make it an enforceable title. So I think this is why it's, at least for the private domain, it's very, again, place to grow there.
But what about communities? I mean, in general, what is the people's perception on collaborative dispute resolution? I mean, what is society structured like there?
I think they don't think about that a lot. I think there are some who, who were trained, and people who were trained, they are very, very eager to do that, and kind of they understand the benefits of it as well. And I think those who are actually, I would even put it that way. I think that those people who are interested in growing as a person, they are always looking for ways to build a dialogue, regardless of the circumstances. So if you are in a kind of simple everyday life situation, or you're in a work or a huge commercial dispute situation, if you are looking for ways to grow as a person, normally they are looking for how to understand the other party as well. And this is where the collaborative approach happens. But if for those, again, who I think are more of kind of, if people want to look for a fight, they will find a fight. So I think it mostly depends on kind of where you want to go as a person. And this is for the community. It also, some of the people are really looking to it as I have my fights and I will fight them, and hopefully I will win, while others are just looking for peace of mind. And I think that the collaborative approach is better in bringing peace of mind to that.
But when you look at the older generation, I mean, do they talk about them resolving disputes within themselves, in families, communities? Is there some history there?
And I think it's not that much as in other cultures, because in some cultures that kind of usually older, wise figure in a family, it's that somebody who you would go to. The whole family would go there, and that word would be very important. I think now we are all getting more kind of individualistic, and you still ask for advice, but it's not necessarily within your family. Of course, you could look, that person could be in your family, but at the same time, you're just looking for your role model, a mentor, and kind of looking for help in resolving the dispute there. But it's not necessarily in that way that, both you and the other party to the dispute would go to that person. It's more of kind of you looking for an advice on how this could be resolved, most likely through a dialogue as well. But it's more of kind of individualistic approach on advice, and less of kind of having that wiser person who everybody in certain community looks up to.
I think that's the interesting thing that you bring up, because this whole concept of this individualistic society that is developing, I think, has moved away from the traditional methods of within the families or in communities. So that is where I think the concept of having professional mediators, that whole demand can go up. I mean, so that the same person who was within the families now comes in from outside.
Mm-hmm.
So I think that
you look for reviews, right? And if you have an issue, you go online, you look for reviews, you look what others did, and then you kind of try to follow that model, and then you collect some recommendations. So yeah, I think that's a very good point you brought. It actually kind of plays for business in that sense.
Exactly. I think that is. But are we into history? You're saying that we don't have too much on the historical part of it in Lithuania. We don't have too much there on how mediation was part of culture there.
We've been part of Soviet society for a long while, and I can't talk about it a lot because I grew up after it was already been already independent. But I think then when you have a regime looking over you, I think this is kind of, I see where it could go through, because I don't think that people were trusting courts back then very much. So I think that was kind of their, let's say, I can't say only way, but the main way to resolve disputes. And I think it did happen in earlier ages, in earlier stages, and in kind of rural communities especially, because I don't know, I think that where my grandma was growing up, or my great grandma, so then the families was the very strong aspect. There was the kind of the head of the family, and everybody would listen to most often he has to say. So I think in those rural communities, it's where like it's the main part where this was of kind of the cultural part of it, of going to somebody to help with a dispute. But it's like I always have this question. I don't know what even you think about it. I think it's kind of, again, it kind of connects to the authority of that person.
Yeah.
It's not necessarily kind of the report building, but it's more of that's the authoritative figure, and we have to look for an advice.
And I think, this is something which is coming up from a lot of places, that actually, first of all, was it mediation? You went to that authority figure and you, most of the time, did you just take what the person said and you did that? So was it really mediation? Because when you look at the definition of the Singapore Convention, it specifically says that the person should not have the authority to impose a decision. Now, that impose part of it, is it a social imposition? Is it a legal imposition? I mean, that is not obviously there. But it does that in that kind of a, say, religious heads. I mean, you have religious heads that people go to, and within, like you said, the elder people in the family or within communities. So what that authority figure, does it have that kind of weightage in their words, that by itself there is some imposition? So so that I think we need to, as we going along, we're discussing with people. I think that part of it, I think, because the point is, I mean, you communicate this concept of mediation, and you find out that people do not really have not even experienced mediation. So it's for them, has, like you said, someone will come and take a decision for us. What is this process that we are going to take a decision? And that's also a cultural thing, that they want that some places. So to be able to communicate the concept of mediation, first you have to go down and explain to them that you can take a decision. So is there a cultural, some kind of, maybe a baggage that you're carrying, that no, we've never taken a decision. How do we take it? And we've come to you, to the courts, because we want you to take the decision. Because we had this discussion in one of our meetings earlier, and I was asking people from all over the world their view on what's happening there. And everyone said, look, people go for arbitration or litigation because they don't want to take decisions themselves.
Yeah, but that's hard, isn't it? You take the responsibility, there's nothing to blame then.
Exactly.
You have to be the one who took it, and then you have to live with it. I think that's kind of a way to reduce your responsibility in that.
Exactly.
Because
That's what came up.
otherwise it's work, right? In one case, you just come up, you lay down your facts, and you say that the other person is wrong, or party, or whatever. And then somebody decides, and they are the ones to blame. But I think that for me, mediation is just a dialogue. And I think that the main function that we as mediators have is to really show the people that they can talk, show the people that the way they use their words matters. And I think this is the role of mediator. It's just showing that they can communicate, and then they look for a solution.
Yeah.
You just that kind of, maybe sometimes when needed, bring down the emotions, maybe structure it, but it's all about the dialogue. And I think that if we are looking into those authoritative figures as in from the perspective of an advice, if that person is kind of teaching how to speak, how to present a problem, so maybe this kind of a mediation, right, is just going through the parties themselves. They have to use the words that a mediator would have used instead of them.
But when you talk about, when you said about the Soviet Union, there was someone from, I mean, Elena is from Russia. She was in the session in the morning, my morning, and she spoke about the mediation being a part of the Russian culture. In Soviet Union also, it was part of what was happening, even in the formal structure also. Mediation was an important part of it. I mean, have a look at that. I mean, if you have time, go through what she was saying. So historically, she was saying that this was part of culture, which was quite interesting. That even with the, with the regime that was there, even they promoted mediation, is what came out from that. So I think that is a certain cultural thing.
That's a very interesting part to look at.
Yeah.
But it's, again, I wasn't even born then. I cannot I cannot give a lot of input on that.
That's one thing I think everyone can guess.
Ah, thank you. I'll take that as a compliment.
Okay. So look, there are some questions there, but I think Kathleen, to steer away from an authoritarian feeling within mediation in Lithuania, how are judges taking responsibility, moving mediation away from them to other mediators? Giovanni, yeah, later. Yeah, you'll just come in. We'll get you in. Yeah.
I don't think they are. I think they're enjoying it. Those who perform mediations, because they're on demand. They're doing what they love. I don't think that they're putting that responsibility back. And I don't think that in many countries, I guess at this point, it's very hard to be just a mediator from the kind of financial perspective. You have to be, I don't know, either very good or really being able to build your practice. But most of the people who are mediating, they still have some kind of careers on the side. Either they are teaching or they are being a psychologist, a lawyer, or whatever. So I think for judges, it's kind of the same. You get bored of one and the same thing that you're always doing. So mediation is kind of a relief, a different nice thing to have. So I don't think that they are kind of trying to push that away. The ones who are doing that. Their superiors, I think they're trying to push that away.
But interesting thing that you talk about in terms of the structure, the way it is developed in Lithuania is similar to what happened in India. But in 1996, we got what is called the Arbitration and Conciliation Act. So conciliation was part of it. Now I don't know how yours was, read, but in our case, that conciliation was totally separate, and it still stays. And that is by itself everything that mediation is. It is mediation. It's called conciliation. But UNCITRAL itself clarified that the mediation and conciliation in the new model law in 2018, they said it's the same thing. We were using the word earlier. We were saying conciliation earlier. Mediation is what we're using now. But in that whole process and everything is very well structured. So I don't know whether you had got the same, because we took the model law, the conciliation model law that UNCITRAL gave. So it was perfect, is what I say. I mean, everywhere you'll hear what we have is the best it can be. So I don't know how yours is drafted.
At first it was, and I think that's again a common trend in Europe. A lot of them were built mostly on the mediation directive and the aspects that are regulated therein. When the first one was adopted, they also were looking into the model law. But I think from what I remember, in Europe, there are only, I think, up to 3 countries that based their laws on the model law. I think Slovenia was one of them, and others that just kind of took the law into account. So the first one was really generic, literally confidentiality, prescription limitation periods, what is mediation, and what the settlement agreement looks like and how it starts and when it's considered finished. But again, I think the worst part of it is that it did not regulate the quality. And for me, it's the most important part actually of the mediation law. It's not even about mediation, right? In a lot of legal acts, we are not even regulating the mediation process itself. So everybody's just like bringing the parties to mediation, then something happens in mediation and we leave that confidential, and that's all, and we are not regulating that, apart from the fact of saying, you can use electronic means or you can go into caucuses. But other than that, the process itself, it's not actually regulated. It's everything that's around it is regulated. So again, the last version of the law, it's very comprehensive and it takes a lot of aspects. But I think that it has to be once mandatory mediation is implemented. I don't think that you can go another way.
So now what we are doing is we're eating into Kathleen's session. So Kathleen, at any point of time, because there is this one question that I want to put through. Reza has a question. Are you okay with me doing that? Or you're okay? You don't have a choice, but you're just supposed to say, yes, I'm okay with it. One question. So how Lithuanian legal system approach mediation in international trade and investment and oil and gas industry? Because he's specifically, obviously, looks at oil and gas industry. So do you have, do you want to talk about?
I will, sorry. I can only say sorry. No, I honestly don't know. I haven't looked into that, and I think it would just simply be understood as a same mediation process, same rules apply, and that's all.
But cross-border,
But again, not an expert here.
but cross-border, I mean, in terms of the EU and all, there is
Yeah, sure.
all
We are
that
not
is
party of the Singapore Mediation Convention, but
that by itself is a whole discussion as to why you're not part of it. I think that we'll keep it for another session. Yeah. So perfect. So what I'll do is let me edit here because I think because it's a birthday, Kathleen's birthday also. I do not want to. But look, there's lots to discuss with you, definitely. So, but we'll take that up. Maybe we'll have another session sometime. But I think at this point of time, thank you very much, Migle. It was very nice,
thank you for
perfect
having me.
presentation. There are good comments there on your presentation. But I will ask everyone to they can unmute themselves and they can thank you. Please, you can thank Migle directly.
Thank you so much. So enjoyable. And it's nice to see you again since Athens. I think it's been 3 years since Athens that we were together at the tournament for the Navy.
Something like that. Yeah. No, good to see everybody. And again, happy birthday, Kathleen and Vikram.
Thank you.
Thank you for organizing these and for bringing everybody together. I think everybody has a very good time here. So thank you once again.
Well, thank you for accepting the invitation and being there and bringing